What is a Frye-Cooper hearing? Hi, my name is Carl Burkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for 8 years now, and I want to help you make law easy by talking a little bit about what a Frye-Cooper hearing is and what does that mean for you. So a Frye-Cooper hearing only applies in cases where you're facing a felony charge. So if you're facing a traffic ticket, a municipal citation, or a misdemeanor, this doesn't apply to you. Just move along. But if you're facing a felony charge and you're past your preliminary hearing, so the first half of the case is over with, you're past prelim, now you're at the district court level and you're getting ready for trial. This is where the Frye-Cooper hearing comes into play. So the purpose of this hearing, is to ensure that your constitutional rights are being protected. This one in particular being to make sure that you have had effective counsel throughout your criminal proceedings. The hearing, God, I keep saying meeting. The hearing is essentially you will show up at the court with your attorney, the state will show up, and you'll go before the judge, and at that point, the judge is going to determine whether or not there's been successful good faith negotiations between your attorney and the state to try to work out some sort of plea arrangement, whether it's dismissal, some sort of plea bargain for a deferred sentence, plea bargain for a suspended sentence, or if the plea bargain includes jail time, how much jail time is involved. Here's the reason for this, because we want to make sure that your constitutional rights are protected, and we want to make sure that you have effective counsel who is not accidentally having you miss a relatively good plea deal that you would otherwise take. An example of this is a case that I had not too long ago. I had a client who hired us after preliminary hearing. So first half of the case is over with. He's got us now, and we're just getting ready for trial or to try to work it out. Now, unbeknownst to us, because we weren't in the case at the time, my client had been given a plea offer before prelim for, I think it was like 20 years. He was facing three consecutive life sentences. But before prelim, the state had offered 20 years, and he rejected that offer. I don't know if he rejected it on his own. I don't know if he rejected it because of his attorney. I wasn't there. I don't know the facts. But what I do know is that by the time we got to the point where we were doing some final negotiations before trial, our hands were already tied. He had rejected the state's offer of 20 years. The state was no longer willing to offer that amount. The lowest that they were willing to go was 35 years at that point. So in this situation, we get to the Frye-Cooper hearing, and the court's acknowledging that his counsel right now hasn't done anything wrong necessarily because of where we got in, but yeah, he rejected one plea. The state's offer is higher, but it's still negotiating in good faith, so there's no violation of his Sixth Amendment rights at that time. But it's still something that the court wants to make sure that you're aware of, because if you end up taking a trial and losing, or end up taking a plea that's not very favorable, the law wants to make sure that you at least understood what your rights were and what the plea offers were up to the point where the case finally was resolved. So if this is something that applies to you, or if this is something where you're maybe facing a felony charge, or you've got Frye-Cooper coming up and you're not sure what the negotiations were, definitely give me a call. My name is Carl Burkhead. I'm with Worth Law Office, and I want to help you make law easy. Thank you.